Hi everyone, welcome to the second week lecture series for the Law on Partnership. For this week, we will be discussing operation and management of the partnership, the rights, liabilities, and obligations of the partners, the liabilities and obligations of the partnership, and the liabilities of the third persons in certain circumstances. So for those who have read the book or are reading the codal provisions, you will notice that I will not be discussing them in the same order. I have decided to um, arrange the articles in such a way that they will be grouped according to the topics that I have mentioned earlier. So if you have any questions, please feel free to ask me through our Facebook Messenger group chat or through Animo Space or my personal email. So I will divide the video into 3 to 4 videos for easy reference. I would suggest that you watch them in the same order because there are some provisions that will be repeated in subsequent videos that I will not be thoroughly discussing anymore kasi I will be discussing them thoroughly the first time around. Yeah, or I will just discuss the pertinent portion of that article. So for this presentation, I decided not to type down the examples or my notes in the interest of time. And so that hindi kayo masyadong maguluhan, you won't feel that there are too many slides per video. I just flashed the articles. Unless the article is so long that I would need a diagram, I will include that in the slide. Or I will just switch to Notepad and write down the example. Yeah, so let's start. So when it comes to the operation and management of the partnership, the first thing that we should ask is, when does a partnership start? A partnership begins from the moment of the execution of the contract unless it is otherwise stipulated. Now, because a partnership is consensual, it exists from the moment of the celebration of the contract. If you remember your law on contracts, the requisites, which would be consent, cost, and consideration, once those are met, then there's already a contract of partnership. Pair that with Article 1767, that a part where two or more persons agree to contribute money, property, or industry to a common fund with the intention of obtaining profits and dividing it among themselves, or where two or more persons agree to form a partnership to exercise a profession. Those are the requisites that must be met before a contract of partnership is executed. So as long as those requisites are met under 1767, then there is already a partnership. Therefore, even if the partners have not yet actually given their contributions, and even if the partners did not agree on the specific profit and loss ratios, there is already a partnership. Kaya if you will notice later on when we continue with our discussion, if the partners do not get to specifically agree on the profit sharing ratio, the law will give ratio for the partnership. So because these are actually incidents to the contract, these are not the main requirements to the contract of partnership. Now, aside from 1767, do remember that under Article 1771 and 1773, there is the further requirement of executing a public instrument if the partnership involves real property. Also, and I will discuss this later on when we get to the final topic of partnership or limited partnership. In limited partnership, it must be in writing, so there's a further requirement. Otherwise, it's informal, it can be verbally made, the partnership. So why is this important? This provision is important because once the partnership starts, that's when you start counting the partner's rights, liabilities, obligations, and the liabilities and obligations of the partnership to each other, to the partners, and to third persons. So, this second part, the unless it is otherwise stipulated, means that the parties can enter into a contract for a future partnership, meaning they have already agreed on the terms. They just agreed that they will start it on another day. So this is not the same as an agreement to enter into a contract later on. When you talk about a future partnership, it means they have already agreed on the material terms of the contract, they have already agreed on what to contribute, what business to do. They have agreed that they will obtain profits and share it among themselves. So much like when you see a long time friend, excuse me, if you see a long time friend and say, "Oy, long time no see, tara, let's hang out sometime." O sige, text. Oh, that, 'di ba? Parang ganon. It's not yet final, 'di ba? So there's no partnership in that sense. Parang you just agreed, "Oy, kamusta ka na? Ano, I heard you're doing good in business. Tara, let's do business." And then you just sabi mo, "Yeah, sige, let's talk about it sometime." There's no partnership yet. Even if they say, "Oh, let's enter into business on for the Christmas season on December." And say, "Yeah, sige." And then there's no specifics entered into or agreed upon, then there is no future partnership to talk about. Okay. Now, let's go to 1785. This article talks about a partnership for a specific term or particular undertaking. If you remember during our first week discussion, a partnership is either at will or for a specific undertaking or a particular term. The difference of the two is about the duration of the partnership. If it's a partnership at will, it is generally limitless. It can go on indefinitely and can end at any time. So, at the will of the partners. Whereas in a fixed partnership, they have already agreed that it will end at a particular date or after the fulfillment of a particular undertaking. Now, in cases where the partners agree to end a partnership on a certain date or after doing something, and they still continue it after whatever that needs to be done has been done, then the partnership is converted to a partnership at will. Why is this important? It's important because the rights and duties of the partners remain the same. If it weren't for this provision, then you have to prove that the partners decided to enter into another contract and it's a partnership at will. Yan. So the law makes it easier. It already assumes if the term is done or the undertaking has already been fulfilled and the parties still continue, then it's assumed that they still form a partnership and it's a partnership at will. Okay. Now, how will you know if the parties continued the partnership or they're already wrapping up and liquidating, which we will discuss later on? The law says, if there's a continuation of the business, meaning they do what is normally done, what's habitually acted, yan, without any settlement or liquidation, it's prima facie evidence, meaning it's assumed that they're doing it to continue the business. Okay, so what type of extension is contemplated? It can be in any form. It can be written, oral, or impliedly by the continuation of the business. So, the implied continuation is here. Okay. So, take note that this only talks about the automatic dissolution and conversion into a partnership at will. This does not prevent the partners from terminating a partnership contract at any time, even before the expiration of the term or even before the fulfillment of the undertaking. Because there's no such thing as an indissoluble partnership. Okay. So let's continue. Now that we know when a partnership starts, let's talk about the name. A partnership shall operate under a firm name which may or may not include the name of one or more of the partners. Those who, not being members of the partnership, include their names in the firm name shall be subject to the liability of a partner. So, the reason for this rule is to distinguish between the partnership and its partners because it has a separate juridical entity. It's easier if they have their own name. Now, usually, we register our partnerships with the DTI and the SEC, especially since most of the capital contributions are over 3,000. And because we follow our intellectual property laws, the firms cannot use a misleading name. Meaning, for you future CPAs, you might not be able to register a partnership name called SGB. B as in boy. Diba? Because it's misleading because there's SGV. Yan. Number 2, and I need you to remember, is that paragraph 2 does not contemplate a situation where a person represents himself as a partner. We will discuss that later on under Article 1825, a partnership by estopel, where a person who is not a partner pretends to be one. So, he will be liable as a partner. In that case, he does not need to be a named partner. That's why this is different. This is also different from a situation where a partner dies and his name is continued to be used, like SGV, Sisip, Gores, and Velay. If I'm not mistaken, all of them are already in the afterlife. So that's not covered here. This is in a case where, for example, I want to do a business. I want to put up a mall. And I want the credibility. So I go to Henry C. Jr. or Tessie C. Coson and say, I'm no one, but I want to do business. Yeah. Why is it okay if I include you? If myself and B include you in the business name, and si Tessie C. Coson allows it, then she will be liable as a partner because she allowed her name to be included. Okay. Now let's talk about contributions. Under 1787, when the capital or a part thereof which a partner is bound to contribute consists of goods, meaning not money, their appraisal must be made in the manner prescribed in the contract of partnership. And in the absence of stipulation, shall be made by the expert chosen by the partners, according to the current prices. So why is this important? For us accountants, this is important because we are the ones who will enter into the books how much is credited into each partner's capital account. So another reason for this is because we will discuss later on, if the parties do not get to agree on a specific profit and loss sharing, their sharing will be in accordance with how much they have contributed. Okay. Another reason for this rule is because a partnership begins at the time that the contract is executed. So they say, okay, I will contribute it also on the same day that we started it. If, for example, I decide, okay, I donate the lot for the partnership with me and B to put up a mall. If I say, okay, I promise I'll transfer the lot to the partnership name on November 5. And on November 11, say, there's an earthquake and that lot's value significantly decreased. If I have successfully delivered the lot on November 5, and it is valued at 100 million pesos, and then the value on November 11 of that same lot decreases to 50 million, the loss of the 50 million will be borne by the partnership, not me. Because I've already appraised it. So, as of November 5, there should have been a credit to my capital account for 100 million. Okay. Next. Now, since we already talk about risk, what I mentioned with the lot that I contribute, 1795 distinguishes between the property that will be contributed by the partners. If the property is specific and determinate, which are not fungible, meaning they're not interchangeable, say that particular lot, and in this example, I only decide to let the business use the lot, but I still own it. So they're allowed to use the fruits. If in that case, I say, okay, we can use my lot to build the mall, but I will still have ownership of the lot. If, as I've mentioned in that example, from 100 million, the lot became 50 million on November 11, then I will bear the risk of loss. Okay, that's because I specifically mentioned that I will only contribute its use. Okay, now, for things that are fungible or interchangeable, okay, or they cannot be kept without deteriorating, say food, or they were contributed by the partner so they can be sold, the risk shall be borne by the partnership, obviously. This is why it's important to have them appraised. Okay. So for the rest of the provisions, please do read them on your own. So when you talk about paragraph 2, please do note your, excuse me, ang pangit. Okay, it's still pangit. Please do note your law on obligations, Article 1164, where there must be delivery. So if there is no delivery and it is lost, then the loss is borne by the obligor, or in this case, by the partner who promised to contribute that fungible property or that properties that's meant to be sold. Okay, so now that we have already talked about when it would when a partnership starts, the name to be used, and the contribution, let's talk about the operation per se. Syempre, we are accountants, so we'll talk about the books. So the partnership book shall be kept subject to any agreement between the partners. So please note this qualifier. It shall be kept generally at the principal place of the business, of the partnership. That's the general rule. Meaning, you can stipulate otherwise. And every partner shall at any reasonable hour have access to and may inspect and copy them. When you say reasonable hour, this usually means business hours. Now, normally that would have been 8 to 5, but of course, if it were a call center, then if it operates at night, then reasonable hours can be at night if that's usually the time that the partners go to the business. So, it's a factual thing. It will be determined on a case-to-case basis. But what is clear is that the Supreme Court in one case said that when you talk about this means that they can inspect it throughout the year. Kasi there's this one case where it was agreed that the partners can only inspect the books from December 1 to 15. So that's 15 days out of 365 days. That's not reasonable, sabi ng Supreme Court. Okay, so this provision is not absolute. Of course, if the information will be used for anything other than partnership purposes. So if say I want to inspect the books, but it's really because I want to put up a competitor firm, then of course I cannot inspect it. Yeah. So because of this provision, the partners are presumed to know the state of the partnership, if it's earning or not. Yeah. So you cannot say you don't know kasi you're given the right to look into the books at any reasonable hour. Okay, so now, who runs the partnership? Every partner is an agent of the partnership for the purpose of its business, and every act, including the execution in the partnership name of any instrument for apparently carrying on in the usual way the business of the partnership, binds the partnership. So, meaning every partner is an agent, and any act which is done in the normal course of their partnership business will be binding. So, unless the partner so acting has in fact no authority to act for the partnership, and the person whom he is dealing with has knowledge. Yan. So, a partner's act will not be binding if he has no authority and the third person knows that he has no authority. Okay. So, if a partner acts in a way that is not in the usual course of business, for example, in the buying and selling of masks, surgical masks, buy and sell of masks, what is not usual would be to purchase the truck for shipping. So, if a partner is going to purchase a truck, that will not bind the partnership, meaning X. For example, I bought a truck from X to ship the masks, and that is not the normal business of my partnership with A, B, and C. Then X cannot run after the entire partnership to ask for the payment of the truck because it's not in the normal course of business unless it is authorized by the other partners. So this unless is authorized by the other partners, in short, is called ratification. I'm just putting it here, this legal term, ratification, for easy reference. Now, except when authorized by the other partners or unless they have abandoned the business, one or more but less than all have no authority to, meaning these 7 things must be done with the authorization of all. You assign the partnership property and trust for creditors, dispose of goodwill, do any other act which would make it impossible to carry the ordinary business of partnership, confess a judgment, enter into a compromise, submit a claim or liability to arbitration, and to renounce a claim. Okay. And in any case, whether it is in the normal course of business or not, if the third person knows that you are not authorized to do so, then the partnership will not be bound because that third person is not innocent. So he cannot profit at the expense of the innocent partners. Okay. Therefore, if it is asked, does a partner have unlimited authority under the principle of mutual agency? Because this 1818 follows the principle of mutual agency. Principle. Please pardon my handwriting. Okay, so if it's asked, does a partner have unlimited authority under 1818? The answer is no, because these are the things that cannot be done by a partner alone. Okay. Another thing. In case it should have been stipulated that none of the managing partners shall act without the consent of others, the concurrence of all shall be necessary for the validity of the acts. So this is in case where there is already a managing partner appointed and they agreed that they should all act together. That's why there's the one for all and all for one. And I will discuss that again later. Let's go first to admission. An admission or representation made by any partner concerning partnership affairs within the scope of his authority in accordance with this title is evidence against the partnership. So as we've mentioned, the partners are agents of the partnership. Therefore, any admission or representation made by any of them, as long as it's concerning partnership affairs and it's within the scope of his authority, will be evidence against the partnership. So, for those who want to study law, under the rules of court, the rules that we use for trial, there is also a similar provision, Section 29, Rule 130, where it says that the act or declaration of a partner within the scope of his authority and during the existence of the partnership may be given in evidence against the partnership after evidence of the existence of the partnership is shown. Meaning, you have to prove first that there is a partnership through other evidence, not through that declaration. So this is important because an admission by one can bind the entire partnership. That's in line with Article 1818 with which we have just discussed. Okay. Now, since we've talked about admission, meaning what a partner says, let's talk about what a third person says to a partner. Under Article 1821, a notice to any partner of any matter relating to partnership affairs and the knowledge of the partner acting in the particular matter, acquired while a partner or then present to his mind, and the knowledge of any other partner who reasonably could and should have communicated it to the acting partner, operate as notice or knowledge of the partnership. In the case of a fraud, except in the case of a fraud on the partnership committed by or with the consent of that partner. Okay, that may be a little bit confusing. Here's the thing. First of all, notice to any partner generally operates as notice to the partnership. You don't need to inform each partner. One is enough. Except if there is fraud done by the partnership or done by the partners. Either the partner who was informed is planning to conceal it, or the partner knew that there was something fishy going on and consented to it. So, for example, in the case given by De Leon, okay, say A, acting for the partnership, bought a parcel of land from D. Before the sale, A acquired some knowledge that the land is involved in a civil case where another person claims to be the owner, say E. Still, A did not tell the partners about this civil case. So, all along the partners think that it is D who is the legal, who has the only claim to that land that they want to buy. Later on, E was able to recover the land. And say, for example, the partnership already moved into that property. They're already staying there. So, if ever they were ejected, A's knowledge is knowledge of the partnership. They cannot say, oh, we didn't know. Kasi, D would say, no, A knew all along that the land was under litigation even before the partnership purchased it. So, the one in the middle, which may be confusing for most of us, myself included, contemplates three situations. Three types of knowledge. One, knowledge of the partner acting in the particular matter acquired while that person is a partner. Two, knowledge of the partner acting in the particular matter then present to his mind. When you say then present to his mind, it means he still remembers. It may be hard to prove if the person remembers. So normally, if it's proven that, say, A was informed even before he was a partner, it is assumed that A still remembers even if he becomes a partner later on. And number three, knowledge of any other partner, meaning one who is not, say in that case, no, it's A who is contracting with D to purchase the land because A is the managing partner. So if B found out about the case over the land, even if he's not the one who is in negotiation with D, so and he knew he was supposed to communicate it because they knew that they were going to transfer their business there, then notice to B is already noticed to the partnership, even if he's not the one who is negotiating, because he could have and should have communicated it to the other partners. Especially now, there's texting, there's email, there's Facebook, there's Viber, there's Telegram, so many ways to inform the other partners. Okay. So, let's continue with agency. We're talking about management. The partner who has been appointed manager in the Articles of Partnership may execute all acts of administration despite the opposition of his partners, unless he should act in bad faith. And his power is irrevocable without just or lawful cause. The vote of the partners representing the controlling interest shall be necessary for such revocation of power. In second case, a power granted after the partnership has been constituted may be revoked at any time. So in this case, there are two situations contemplated. One, a partner appointed as manager in the Articles of Partnership, and two, a partner appointed after. So in cases where the partner is named managing partner in the Articles of Partnership, you would need the vote of controlling interest to revoke that power because it will be a novation of the contract. If you remember your law on contracts, a novation is a change in the principal condition of the contract. So, here, the law says that the power of that managing partner can be revoked only if there is just or lawful cause. What if you just want to remove him because you just don't like that managing partner anymore? No particular purpose. You think na pangit lang siya, doesn't look good, di ba? Then you can, because there is no such thing as indissoluble partnership, then dissolve the partnership because you're already changing the contract. You want out, di ba? That's on the side, no? Yeah. So something else. But if the partner is appointed after the constitution of the Articles of Partnership, then you don't need a reason, you don't need controlling interest because it's not a condition in the contract. Okay. Also, take note that a managing partner can execute all acts of administration, not disposition. Meaning they can do whatever needs to be done in the normal course of business. Say, for example, in relation to the property I mentioned a while ago, he can pay real estate. He can make sure that the property is maintained, but he cannot sell it. He cannot sublease it because that is an act of disposition. He cannot assign it to someone else. Yeah, that's what it's meant when you say acts of administration. What if no one is appointed manager? Remember, under 1818, every person is an agent. And we will discuss this later on also when we talk about other stipulations when it comes to management. Okay. What is a managing partner's scope of power? Let me just continue with the managing partner since we've started it already. The general rule is that they can do things that are in the normal course of business, like issue receipts, purchase on credit if they normally purchase on credit, and dismiss an employee. What are the exceptions? Number one, those that are specifically stated that the partner cannot do, whatever it may be. Number two, those that are not incidental to carrying out the object of the partnership. So, for example, in a case stated by the Supreme Court, where the partnership was in the business of buying and selling fish in Manila, they said that the manager cannot purchase a barge or a truck because the business was about buying and selling fish. Now, it may be that the truck may be used for the fish, for the buying and selling of the fish, but it's not the normal course of business. Also, something that I thought of that may be practical. So, A, B, and C enter into a business to sell masks. A is the managing partner, so he can purchase masks, sell masks, appoint a bookkeeper, hire a bookkeeper if that's the normal business naman. But A cannot lend out the money of the partnership to other people because pautang or loaning is or extending credit is not part of the business of selling masks. Okay. So let's continue. If two or more persons have been entrusted with the management of the partnership without specification of their respective duties, or without a stipulation that one of them shall not act without the consent of others, each one may separately execute all acts of administration. But if any of them should oppose the acts of the others, the decision of the majority shall prevail. In case of a tie, the matter shall be decided by the partners owning controlling interest. Okay, so let's chop this provision up. This case contemplates a situation where there are two or more partners who have been entrusted with the management. Okay. If there is no express agreement that A should do purchasing, B should do shipping, it is assumed that each one may do all acts of administration. So, for example, in the case of A, B, and C, where they enter into the business of buying and selling masks, A will buy, B will do the selling, C will do the accounting. Let's assume if there's an agreement that that's what they will do, then we will follow the agreement. If there is no agreement, it just says A and B are the managing partners, then both of them can buy and sell, can do whatever they need to do. If there is a stipulation that they should act all together, then that's where Article 1802 will come in. If you remember the previous slide a while ago with the three girls holding up fencing swords and saying all for one and one for all. Yan. So, in that case, where it is agreed upon that all the managing partners should act together, then it means that the consent of all is needed so that the acts will be valid. If you don't have the consent of all, then the act is not valid. The partnership will not be liable. Okay. In that case, the absence or disability of any one of them cannot be alleged. For example, A, B, and C say, okay, we're all managing partners in this business of buying and selling masks. We will all work together. We need the consent of everyone. It so happened it's raining, especially now that Typhoon Roll is coming, and they say, and it happened that A lives far away, say in Bicol, where which is expected to be hit the most. B and C now cannot say, oh, you were so far away so we didn't even bother to ask you if we can buy 100,000 worth of masks because it was agreed that they should all act together unless there is imminent danger of grave or irreparable injury to the partnership. What does it mean? Say, for example, in the case of A, B, and C buying and selling masks, they have a condo unit in Manila beside DLSU where they have all the masks worth 100,000 and there is a fire. They don't need to call A to ask, oh, A, can we move the masks and move them to the house of B? Because obviously, if they don't do that now, then there will be a danger to the partnership. If, for example, that's all the masks that they have. Without it, they will lose. They will lose all their money. Now, if I may segue, so you can opt not to listen to this if you don't want to. What if it is asked of you that in the case of masks, they buy the masks for 2 pesos and they need to agree that if ever there's anything that they need to do, they will get the consent of everyone. Say B and C are in the condo unit. And there's a supplier that comes and says, how much are you buying your masks that you're gonna sell? They say, oh, we're buying it for 2 pesos. And we're selling it for 5. And the supplier says, you know what? If you buy twice the amount, meaning 100,000 pieces, instead of selling it to you for 200,000, I'll sell it also to you for 100,000, meaning 1 peso na lang yung mask. But I'll give you until midnight. Is that, do they need the consent of A, or can they say, no, we really needed to act fast in the interest of time, or else there will be grave or irreparable injury to the partnership? There won't be, because their failure to buy at a bigger discount is not necessarily grave or irreparable injury. Not irreparable, irreparable. So, they will lose, sure, but it's not grave. It's not something that cannot be repaired. Yeah. So, let me go back to 1801. Okay. In a case of 2 or more partners, each one may execute any act if there is no stipulation to the contrary. But if any of them should oppose, then the decision of the majority shall prevail. Okay. In case of a tie, the matter shall be decided by the partners owning controlling interest. Okay, let me give an example under Soriano. Here. Maryland Company is owned by the following partners with their respective contributions. Let me just open a notepad. Okay. Maryland Company is owned by Mary, who contributed 10,000. Anna, who contributed 20. Rose, who contributed 30. Irma, who contributed 40. And Liza, who contributed 50. Sorry madami. So much. Edna, who contributed 100,000. And Nora, who contributed 200,000. Okay. Let's assume that these are the managing partners, MP. Okay. If Mary, without any specification as to their duties, it is assumed that Mary, Anna, Rose, and Irma, and Liza can do any act of administration if it's in the normal course of business. Now, what if, for example, let's do face masks. Mary wants to purchase the 200,000 worth of masks. If, say, Mary wants to purchase, if anyone wants to oppose, say Anna says, no, I think 200,000 is a lot. We already have 100,000 worth of masks. Then, Mary, Anna, Rose, Irma, and Liza have to vote. When you say majority, you're talking heads. So, out of 5, you need at least 3. If Mary, Anna, and Rose say, okay, let's continue with the purchase, then Mary's action, the group of Mary will prevail. Okay. Now, let's say, in this same example, Mary and Anna say, okay, let's continue with the 200,000. Irma and Liza say, no, I don't want. And Rose says, guys, I don't want to be caught in the middle. I abstain. Therefore, this is a tie. What will happen? Now we need to get the vote of controlling interest. So how do you do that? Now we'll add. How much is everything here? 300, 400, 450,000. Meaning, you need to get the vote of the partners holding at least 226,000. Tama ba? Yeah. That would be the controlling interest. That's what it's meant. That's what is meant by the provision. Okay, now let me just go back. Now, it's a little bit confusing because that case, there's so much. And in fact, if you're reading De Leon, and I took the liberty of reading 3 to 4 books to simplify, so that you guys don't need to buy books anymore. Some of you might be confused. Some of you might say, I think Soriano says, controlling interest refers to the interest of the managing partners. But De Leon says, controlling interest of the entire partnership. Now, I conferred with Attorney Reg Laco, who's also teaching Actors 31. Sabi niya, it's not a practical thing to think about because normally, the managing partner has the controlling interest. Of course, if I have the controlling interest, I'd want to manage the firm because I'm the one who wants the business to succeed the most. So, the reason why I'm explaining this is because if ever it shows up in the board exams, that would be your call. Who you'd want to follow, whether you'd want to follow the controlling interest of the managing partners, meaning if I may go back, no, under the view of Soriano, since there is a tie, you'll have to look. Irma and Liza have 90,000 interest versus Mary and Anna who only have 30,000. Under Soriano's view, the one who will win is Irma and Liza, meaning, okay, Mary cannot buy 200,000 worth of masks. But under another view, you're looking at the controlling interest, meaning you need to have Edna and Nora vote. So I just want you to know that and hope that it's not asked in your board exams. So don't hate me. I want to make it easier for you guys. But I don't think it will be asked. At least for our midterms and our finals. Okay, so again, please be careful when we talk about when we talk about anyone who is opposing the acts. The first decision would be the decision of the majority. We are talking about the vote count, not how much not how much interest that voting partner has. Okay. Okay. Now let's talk about when the management has not been agreed upon. And I've already discussed it in passing a while ago. When the manner of management has not been agreed upon, the following rules shall be observed. Number 1, all the partners shall be considered agents, and whatever any one of them may do alone shall bind the partnership, without prejudice to the provisions of 1801. And as I have mentioned a while ago, 1801 is they can execute all acts of administration, which I just mentioned a while ago, just now. And number 2, none of the partners may, without the consent of others, make any important alteration in the immovable property, even if it may be useful to the partnership. Because the reason why the law provides for this is because the partners might say, the alteration of the immovable is in the course of business. It's not a disposition. I'm just changing it. Diba? If you remember, I previously mentioned all partners may do all acts of administration. Not disposition. They say, I'm not disposing. I'm just altering or renovating the immovable. Here, the law is making it clear, okay, if ever that happens, they cannot make any important alteration, even if it's useful to the partnership, if you don't have the consent of others. But if the others are not consenting just because they're being hard-headed, ayaw lang nila for no justifiable reason, and it's prejudicial to the interest of the partners, then you have to go to court. You cannot make a judgment call and say, it's prejudicial to the interest. It will be the judge who will decide. Yeah, it looks like their refusal is unfounded. Okay. Okay. Now let's talk about still under management. Let's talk about the money that goes to the partnership. If a partner authorized to manage collects a demandable sum which is owed to him in his own name from a person who owed the partnership another sum, the sum thus collected shall be applied to the two credits in proportion to their amounts, even though he may have given a receipt for his credit only. But should he have given it for the account of the partnership credit, the amount shall be fully applied to the latter. The provisions of this article are understood to be without prejudice to the rights granted to the debtor under Article 1252, but only if the personal credit of the partner should be more onerous to him. Okay, so Article 1252 refers to preference of credits. When you say preference of credits, kasi usually, a debtor can choose where the payment will be applied to first. Now, in this case for partnerships, if the personal credit of the partner is more onerous, then if he issues then it will be an exception to the general rule under the first paragraph. Okay. Now, if I may explain, and I may illustrate it to make it easier. Okay. So, if for example, A is with in a partnership with A, B, C and company, and X owes A 100,000 and owes A, B, C and company 200,000. If X pays 300,000, then that's a no-brainer. Pay 100,000 to A, pay 200,000 to B. But if, for example, X goes to A and says, I only have, say, 60,000. Tama ba? Yeah. X says, okay, I only have 60,000. And A says, okay, I'll issue you an OR for 60,000 for the payment of your debt to me, 100,000. The law says it's not allowed. If you are that's not allowed under the provision of the law. It says if you issued an OR under your name and X owes both you and the partnership, so that you will not take undue advantage that will be detrimental to the partnership, this will be split proportionately. So 20,000 goes to A, and ABC gets 40,000 of the 60,000. Diba? 1:2. But if in a different example, X says, here's the 60,000, here's 60,000 of the 100,000 I owe you. And A says, okay, sure, 60,000. And then A wrote A, B, and C company. Because it's written there, it cannot be it will not be prorated between the two creditors. The whole 60,000 will be to A, B, and C. So, I just illustrated it to make it easier to understand the provision. This is in cases where if a partner is authorized to manage the business. Meaning, A, B, and C company, B is not the managing partner. X goes to B and says, hey, here's the 100,000 I owe you. And B writes an OR under his name. If he's just a silent partner, then this rule will not apply because this 1792 requires that a partner must be authorized to manage the business. And the reason for this rule is because the law wants to safeguard the interests of the partnership. It's to prevent undue advantage to the managing partner. So, how will we know who is the managing partner? Look at 1803, which we discussed earlier. So, what is more, let's go back to what is more onerous. What do you mean when you say more onerous? Usually, these are cases where when you say more onerous, say the loan to A has interest, or has a higher interest, or the loan to A has a pledge or mortgage. So if in that case, even if A issues an OR under his name because X said, oh, here's 60,000 of the 100,000 I owe you, if the loan to A is secured by a mortgage and the loan to the partnership is not secured by any mortgage, then the entire 60,000 goes to A, because X, the debtor, must choose. He must say, oh, this 60,000 is for you. What if it's more onerous, but the debtor just hands him 60,000 and A issued a receipt in his name? Follow the first paragraph in that case, okay? So take note, the more onerous clause applies if the debtor says, this is to be applied to my more onerous obligation. Okay. Now let's talk about the disposition of property. Conveyance of real property. So I'll give you a minute to read it, as I will read it as well. Okay. When title to or real property is in the partnership name, any partner may convey title to such property. Okay. So if you read everything, sorry ha, I'm running out of saliva here, especially with my expanders. What I did was I created a table for you. So you can take a picture and just crop me out. So in the article 1819 contemplates 5 situations. Number 1, this is where, okay, this column talks about title. If the title is under the name of the partnership, and the transfer of title, meaning in the deed of sale, is written that ABC and Company as the seller. Diba? If the title is under the name of the partnership and under the deed of sale, it is ABC that's selling, then there is a transfer of title. Okay. Wait lang ah. Sorry. Let me just... This is 1819. Okay, I'll repeat it again. If the property, okay, I'm gone now. If the property is under the partnership name, and say one partner A sells the deed, but the deed says it's under the name of A, B, and C. So assuming the first paragraph goes under the assumption that A was not really authorized to enter into that contract. There is still a transfer of title because the named owner, the registered owner, executed the deed. Then there will be a transfer. However, since A is not really authorized, then the partnership can still recover that piece of property unless Article 1818 applies. What does that mean? Article 1818 applies. If you remember, under the doctrine of mutual agency, a partner is an agent and will bind the partnership for anything that is in the usual course of business. What does it mean? If ABC and Company is really in the business of buying and selling real estate, even if A was not really authorized, because the buyer is can assume that A is authorized kasi it's in the regular course of business. Or IPFV. What is IPFV? This is an innocent purchaser for value. I just shortcutted it. Gave a shortcut, excuse me, rather. What does it mean? If, for example, ABC and Company is not really in the business of buying and selling property, and can the partnership still recover if it is sold to X? The answer is no if later on X sells it to, if X is an innocent purchaser for value, meaning he doesn't know, or he doesn't know that A was not authorized. Really, he thought he was. Say, A was holding a special power of attorney. Diba? Or, for example, X knows that A is not authorized, so he bought it, so he's not an innocent purchaser. But X sold it to Z, who is an innocent purchaser for value. Then, what happens is that A, B, and C, Company cannot recover anymore. Okay, number 2. If title is in the name of A, B, and C here, but the conveyance is executed by a partner in his own name, then what is passed is only equitable interest. But it must comply with Article 1818. Again, that only means that the execution is for carrying on the usual way of the business. Okay, what is equitable interest? Equitable interest is beneficial ownership. What does it mean? This is not legal interest or not legal title. Yan. So, meaning ownership is not passed to does not pass to the purchaser, but it must comply with Article 1818. Okay. Now that we have explained these terms above, we can continue faster with the third, fourth, and fifth paragraph. Number 3, where the title is in the name of one or more but not all. So, for example, A and B, not C. And the record does not disclose the right of the partnership. Say it's not annotated in the title. The partners in whose name the title stands, A and B, can convey the title. If they're the ones named in the deed of sale, the title will pass to X, the purchaser, but the partnership can recover. Again, similar to the first situation, unless Article 1818 applies or the property is with an innocent purchaser for value. Okay, number 4. Where the title to real property is in the name of one or more or all or a third person. Meaning, if the title is in the name of anyone, but it says there that it is in trust for the partnership, and that deed of sale is executed in the name of whoever is title is written in the title, then what is passed is only equitable interest. Why? Because the title already states that it is in trust for. Okay, and lastly, if the title is in the name of all, a conveyance executed by all of them passes all the rights to the property, obviously, because it's already, it is already consented to by the whole partners, by all the partners. Okay. So I will not give any more examples because I think the diagram speaks for itself. However, if you want to ask for examples, do message me so that I will post it for the class. Otherwise, I will forget. Now, there's a qualifier. In all these cases, these can be ratified. What does it mean? If you remember, there are cases where title will not be transferred. Diba? Only equitable interest will be transferred. Or, there are cases where title may have been transferred, but the partnership can still recover if it's not with an innocent purchaser for value. There is still an exception. If all the partners ratify. What do you mean ratify? They approve of it. And how? How will they ratify? It can be through their act, meaning you can tell from their conduct they were there. It's possible, in this case, it's in the title is in the name of A, B, and C. But the one who executed the deed was under the name of A seller. If B and C were there during negotiation and during the signing of the deed of sale, then you can say they ratified because they were there when they executed the contract. Kasi when you talk about immovable property, delivery is execution of the contract. You cannot physically deliver the parcel of land to the buyer, diba? What are you gonna do? Excavate? No, you just execute the public instrument. Or ratification can also mean when they accept the benefits. For example, in the case of selling property, this property was sold for 300 million pesos. So if A and B and C, if only A did the executed that contract, and then A gave B and C 100 million each, kasi that was all profit, assuming for the sake of simplicity of the example. If B and C accepted 100 million, it's assumed that they have ratified. Why? That's a large sum. That's 110,000. Unless they think it's for something else, meaning for the normal course of business, which is highly doubtful. Then you can say na by accepting the benefits, you have ratified. You have agreed. Kasi it would be unfair. You'd accept the benefits and then later on, you'd want the contract nullified. Say, oy, I didn't know, diba? It violates 1819 of the Civil Code. Okay, so, almost done with the first video. Bear with me, guys. Okay. If there is no agreement to the contrary, in case of an imminent loss of the business of the partnership, any partner who refuses to contribute an additional share to the capital except an industrial partner to save the venture shall be obliged to sell his interest to the other partners. What does it mean? In case of an imminent loss of the business of the partnership, if you want to continue the business, of course, you'd need additional capital. And the assumption is everyone would contribute except industrial, because an industrial by nature only contributes his industry, his services, his expertise. If in case one of the capital partners does not want to contribute, it means he doesn't want to continue with the business. So, they can be obliged to sell the interest to the other partners. Because the other partners might want to save the partnership. Okay. So, what is the requirement here? The requirement is that a majority of the capitalist partners are of the opinion that an additional contribution to the common fund would save the business. So, here, the refusal contemplates a refusal, a deliberate refusal, and not because that person is financially constrained. So, in the case of A, B, and C, if A, B, and C are all capitalist partners, and they're losing money from that selling of surgical masks, and they say, hey, we need to infuse 30,000 more. They can say, oh, let's each contribute 10,000 if assuming that their contribution is equal, no, that was their agreement. When you say refusal and B doesn't want to give, it means he just doesn't want to, not because he's broke or he's illiquid. There. And last, 1827, the creditors of the partnership shall be preferred to those of each partner as regards the partnership property. Without prejudice to this right, the private creditors of each partner may ask the attachment and public sale of the share of the latter in the partnership assets. Meaning, if you're running a partnership, and because it is a separate juridical personality, the creditors of the partnership will be preferred over the partners. So, as we have said, under 1812, which we will discuss later on, a partner's share in the business is only the profits plus surplus. So, since the creditors are preferred, it's in harmony with 1812. The partners cannot say that they should be paid first because they can only get the surplus. But without violating the first sentence, the private creditors of each partner may still ask for an attachment of the share. Meaning, okay, in an example where, say, A, B, and C contributed 30,000 for the surgical mask business, and they're at a loss of 20,000 pesos. And if they have 30,000, and they have liabilities of 50,000, so there is a shortage of 20,000. The creditors of A, say A has his own personal obligation, personal loan to X. X cannot say, wait, I need the 30,000 first. Or if, for example, the business is earning, if the profit was, X cannot say, I have to be paid first before the creditors. No? So, but he can attach the share of A if ever A has any shares. So, it's like an expectancy. No? Yan. So, okay. So, let's continue with the parts of operation relating to profit and loss arrangements. So, When it comes to profit and loss, there are three particular provisions of the Civil Code. They're actually one after the other, so it's easier to understand. They're covered by Article 1797, 1798, and 1799. Okay. So, under 1797, the losses and profits shall be distributed in conformity with the agreement. If only the share of each partner in the profits has been agreed upon, the share of each in the losses shall be in the same proportion. In the absence of stipulation, the share of each partner in the profits and losses shall be in proportion to what he may have contributed, but the industrial partner shall not be liable for the losses. As for the profits, the industrial partner shall receive such share as may be just and equitable under the circumstances. If besides his services he has contributed capital, he shall also receive a share in the profits in proportion to his capital. For 1798, if the partners have agreed to entrust to a third person the designation of the share of each one in the profits and losses, such designation may be impugned only when it is manifestly inequitable. In no case may a partner who has begun to execute the decision of the third person, or who has not impugned the same within a period of 3 months from the time he had knowledge thereof, complain of such decision. The designation of losses and profits cannot be entrusted to one of the partners. And lastly, a stipulation which excludes one or more partners from any share in the profits or losses is void. Okay, so let's start with 1797. When you talk about profit and loss, do not confuse this with liability. Given that you're composed of accountancy students, I will not elaborate on the differences between the two, as I assume that and you are supposed to know it by now. So, if you look at 1797, there are 3 steps. The first order is the agreement of the parties will prevail. So, whatever that share may be. Number 2, if there is no agreement as to loss, then the profit ratio will be used also for the sharing of the loss. Meaning, if you look at number 2, it shows that under number 1, when there is an agreement, the partners can agree on a different ratio when it comes to losses. So, for example, in a case of a partnership between A, B, and C, it is possible that the profit ratio would be 50% goes to A, 30% goes to B, and 20% goes to C. But when it comes to losses, 20% of the loss will be shouldered by A, 30% will be shouldered by B, and 50% will be shouldered by C. And that's completely normal, and that's valid because the partners may agree to any stipulation of terms as long as it's not immoral, diba? Okay. So, 1, agreement again. 2, the loss sharing will be equal to the profit sharing if there is no stipulation as to the losses. And number 3, if there's absolutely no stipulation, then the sharing of each partner will be in accordance with what was contributed by them. Therefore, in the case of A, B, and C again, if each of them contributed 100,000 to the partnership and there is no agreement as to how they will share profits and losses or profits, so there's no stipulation at all, then they will each share 33% because they're contributing equally. No? Okay. So, for those, in cases where there is an industrial partner, therefore, what the industrial partner is contributing does not have a specific value because you cannot really value services that way, no, when it comes to partnership. So, for example, there's A, B, and C, and D. D is the industrial partner. A, B, and C contributed 100,000 each. The law says that the industrial partner shall receive a share that may be just and equitable. Okay, so what is just and equitable under the circumstances? Usually, the parties can already discuss what is just and equitable amongst themselves. In my opinion, if they think that they cannot agree on it, usually either they go through arbitration if it's in the clause or they go to court. There is an old view, which I think Soriano mentioned, that the old civil code, technically the one that we are using now is called the new civil code, even though it's a really old law. The old civil code back, older than this one, uh, stated that an industrial partner's just and equitable share would be equivalent to the share of the capitalist partner with the least capital contribution. No, now I, along with others, don't subscribe to this view since the industrial partner's efforts may be more than the capital contribution of the partner. Although I did state that a person's industry cannot be given any specific numerical value, there are cases naman na obvious that the industrial partner uh, exerted more effort. So, I, along with others, don't subscribe to this old view, no? Especially since later on, when we go on with our discussion, you will notice that the industrial partner is not allowed to engage in any business. This is to ensure that the capitalist partner is loyal because his contribution is his work, his industry. So he or she is prevented from engaging in other business unless allowed by the other partners. So it would be unfair if he gives all his industry, and if there's no profit and loss ratio, he will only get the same share as that who contributed the least. And what if the capitalist partner, in the example of A, B, C, and D, what if A gave 100,000, B gave 20,000, and D gave 1,000? So does that mean that D will also get the same share as C, who only contributed 1,000? Unfair, diba? Yeah, so I think I belabored that point. Um, so for 1790, excuse me, before I miss out on anything, an industrial partner shall not be liable for the losses. This is because unlike a capitalist partner where they can actually withdraw their capital contribution, an industrial partner cannot withdraw the services he already rendered. This is why he or she is not liable for losses. And besides, there's also a view that once an industrial partner already gives his or her service, that's already a loss if they don't get anything in return. Under 1798, which I have already read, talks about the designation of the profit loss ratio sharing to a third person, and that is valid as long as it's not manifestly inequitable. Now, you'd be wondering, why would it be manifestly inequitable if it's already given to a third person? It's possible that, and this is just my guess, it's possible that one of the partners connived with this third person. Syempre, the law is giving the innocent partners a remedy to have it impugned. Now, to impugn it, meaning to oppose this sharing given by the third person, the law gives a prescriptive period. When you say prescriptive period, there's a time limit, and that is 3 months from the time he had knowledge. If from the time that he had knowledge, which they have to prove when it starts, from that time he or she does not complain, then it is assumed that that partner agrees to the sharing ratio given by the third person. So to be practical about it, usually what happens is a third person will give the ratio and they will include it in the articles of partnership. So when you say that, that means the time that all partners have knowledge is at the time that they sign that articles of partnership. Syempre, you wouldn't sign something you did not read. So, never sign something you don't read thoroughly. Yan. And then the second paragraph of 1798, which states that the designation of losses and profits cannot be entrusted to one of the partners, is actually in harmony with the law on obligations, particularly Article 1308 and 1309 of your Civil Code. You have already discussed this before with your previous professor, where the fulfillment of the contract cannot be left to the will of one of the contracting partners alone. So, in this case, and this is my interpretation, In cases where, say, there is A, B, and C in a partnership, it is not allowed that only A will create a profit and loss ratio because, of course, he will be biased and create a sharing that will be advantageous to him, to A. But if it were designated to A and B, then if you look at the wording of the law, it's allowed because it only says that it cannot be entrusted to one. It doesn't say that it should be entrusted to all. Okay. Before I leave, the reason why there is a 3-month time limit under paragraph 1 is to avoid any paralyzation in the operations of the partnership. Okay. Now, here's the thing. What if it was actually entrusted to a third person who creates a profit sharing ratio that is manifestly inequitable? Or what if it is entrusted to one of the partners? What happens then? Is the partnership void? The answer is no. Here, only the stipulation is valid. Ano? Okay. If you look at 1799, a stipulation which excludes one or more of the partners from any share in the profits or losses is void. Now, please take note that what is void is the stipulation, not the partnership contract. Therefore, if A, B, and C enter into a contract of partnership where they said that C will not participate in the losses and C is a capitalist partner, only that provision is void. What will happen then? The partnership continues, and we will therefore apply Article 1797. And that states, let me just go back to that for easy reference. 1797, paragraph 2 states, in the absence of stipulation, the share of each partner in the profits and losses shall be in proportion to what they have contributed. But the industrial partner shall not be liable for losses. Okay, therefore, if there is an agreement, I'll give another example. In a partnership with A, B, C, and D is an industrial partner, and the partnership contract states that D will not be liable for losses, that stipulation is valid because under the law, an industrial partner shall not be liable for losses. Okay. Now, looking at this, in my opinion, if you look at 1798, if I may go back, paragraph 2 states that the designation of losses cannot be entrusted to one. What if it is? If you follow the logic under 1799, it means that the partnership contract is also valid, but only the stipulation on the profit loss sharing will be invalidated. So, in cases where the designation of losses and profits is entrusted to only one of the partners, then you will also use the profit sharing under 1797, meaning follow the capital contributions of the partners. Before I forget, class, I'm so sorry to interrupt. And I'm sure you guys are hoping that the video would end. Just one more minute. I forgot to mention that where the inequality of sharing is so gross, it can be considered a simulation or an indirect contravention of 1799. Meaning, yes, we can entrust the designation of profit and losses to a third person, but if the sharing is so unequal, then it means you can strike that down. Because as I mentioned in the first set of videos, what cannot be done directly cannot be done indirectly. There. So I just wanted you to remember that. Yeah. So that ends the first video. I hope you guys did not fall asleep if you're watching this at night. And please Please brace yourselves for Typhoon Rolly. I really pray that everyone will be safe. And I hope that this video lecture will actually be more beneficial to everyone so that you can watch it at your most convenient time. And I hope to do a synchronous class for all our lectures so that when we meet through Zoom, we will just be discussing question and answers. And from the time that you watch the video till the time that we meet, I do plan on reading up on Supreme Court cases just to update you, because I would want this also to have a practical approach. So, but rest assured, I'm not treating you like law students. I don't expect you to memorize the laws. I'm just looking at examples. Kasi sometimes, the examples under De Leon's book are honestly outdated. Yeah, so I'll see you in the next video, guys.